Welcome to Hull and Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana popovic-montag. These podcasts will provide information and insights into estate planning in Canada. From the offices of Hull & Hull, here are Ian and Suzana.
Hi, and welcome to Hull and Estate and Succession Planning. You're listening to episode 149 of our podcast on Tuesday, January 27th, 2009.
Hi, Suzana.
Hi there, Ian. How are you today?
Fantastic, thank you.
That's good.
So please come to our website, look at our information, and browse around. Look for our daily blog at estatelaw@hullandhull.com.
And if you have any comments or would like to pass on any thoughts to us, please feel free to contact us at hullandhull@gmail.com.
Well, Suzana, we're working through the concept of what a shareholders agreement is, and more importantly, how that can be an important tool in the context of an estate plan. And focusing on the fact that the efforts to create a shareholders agreement in and of itself forces the family to consider what they're going to do with the estate plan and where they're going to go forward, and it creates its own agenda. We finished off the last podcast talking about really was the starting point in the shareholders agreement and what the first thing you're going to look for, and that is what is the nature of the business. So once we've established the nature of the business, whether it's an investment holding company or it's an active operating company, the next thing I think is worth looking at is really the types of legal entities that are involved. And we can't forget that there are really there are a variety of choices, but there's the classic corporation, then there's the classic trust that are used in many of the estate planning scenarios, and then there's the sole proprietorship or the unincorporated entity.
Actually, and just to add to that, I was thinking a little bit about the fact that, we can use these kinds of processes and these kinds of discussions also when you're dealing with partnerships. And I was just thinking from a legal perspective, you'll see many times a father-son or mother-daughter kind of family partnership that involves legal services or other services for that matter too. And so a lot of the concepts that we're talking about, I think, lend themselves into that kind of situation as well.
No, it's a really good point, because really we can talk about two entities, two tools. One is a shareholders agreement, another is a partnership agreement.
Right.
And the partnership agreement would be set up in a classic scenario. Say a father and son were working in the business. The son had come into the business, and the business was a book selling company, the retail business. So they had a bunch of different stores and so on. The father had started with one and grown it. The son gets into it. Just one son gets into it. What they'll do is they might create two separate holding companies for their specific shareholding interest.
That's right.
But they're operating one business. So a partnership agreement there, as between the two business entities, would be a really good tool. So that's a great point, and one that we shouldn't forget, in that really we're talking about, and we may want to talk separately about partnership agreements, but the general concept of a contract governing the behavior of the parties beyond a will.
That's right.
Okay, so that's a great point. So we got to look for the entities itself. And the sole proprietorship is not an impossible scenario either, when you've got a situation where you start small, and we stay with the book company, and it was just at one point a small book company in a mall and grew. And the entity itself was started off as just an entity and wasn't incorporated. So really what I think is important is A, looking very hard and looking at what the corporate structure is and what exactly the entities are, and B, reconsidering whether or not at this point in time maybe we have to upgrade the entity or change the entity. The other aspect of it, of course, is that in a classic estate freeze, a trust is used to hold the shares or the common shares for the, and we can talk through an estate freeze in more detail, but the point is that entity is there. So it gives us an opportunity, A, to consider the entities, and B, to consider what those entities mean with your family, so that the kids understand why there's a trust, or they understand why there's a partnership agreement, and so on. So it's a learning tool as well.
And the communication that surrounds all of that planning, I think, is key, because then you can put collectively your minds to the different scenarios, the different possibilities, and as a family, as a family unit, you can make those plans going forward.
All right, that's terrific. So a subset of what are the entities is, of course, who are the shareholders? And let's spend some time thinking that through and why that, again, allows for communication, allows for all of the things we want to encourage, but why it's important legally.
Right. And from a legal perspective, and the reason that it matters who the shareholders are is because we need to identify who the owners, in effect, are, because shareholders are the owners of a corporation, just like partners are the owners of a partnership. And so being able to identify who they are, what percentage of an interest they have, which will normally bring with it some level of control or direction of the company that's involved, helps to identify those kinds of issues in a plan.
All right, and let's just talk about, we don't want to get overly corporate, we don't pretend to be corporate lawyers or tax lawyers, but with the context of a shareholder, there are different variations on the theme, but there really are the two central thinking, is that there are common shareholders and there are pref shareholders.
And when you say that, Ian, what's the difference between that? Just from, a view above ground, not too complicated.
Well, that's right, and I was going to ask you that question.
I beat you to the punch.
That's right. Because, and where it's best illustrated is when you get in a situation where you want to pass on the growth of the company to the next generation. So the husband or the mother sets up the book company, and she has run this book company for many years. She's the sole shareholder. She has 2 kids. One of the kids wants to come in, the other kid doesn't want to come in. She wants to stay in control because she knows how to run the business. So what she will do is she will essentially freeze her value in the estate freeze context and pass on the growth to the children. And the way she passes on the growth to the children is that she passes the common shares to the children, and she leaves the pref shares in her hands, which allows no growth. You fix the price, so say the company's worth $100,000 at that point. You say the fixed price of the pref shares is $100,000, but the growth is all to the common shares. And so you've allowed control at the level where it needs to be, because the pref shares will hold not just the fixed value, but they will typically hold the control votes. And then the growth shares will be enjoyed by the kids at a very tax efficient way.
Now, Ian, even though those are sort of the normal attributes attributed to the respective shares, the common shares and the pref shares, is it possible within a planning context to change any of those attributes?
I don't know exactly what you're getting at, in the sense that we can vary it for sure, but what do you mean?
Can you draft so that you can add maybe more power? Can you give common shareholders power, for instance, to make decisions, or is it really just key with the pref shares?
Well, I have no idea. Because no, I'm just joking, but and from a corporate standpoint, we just don't have the expertise to, I don't have the expertise to address how we're going to reflect the common shares and the pref shares, but what you can do is, of course, create different layers.
Right.
So you might create X-class shares or Y-class shares, and in that you may give special powers or special voting rights or even special growth.
Right.
There's tax deferral that you can put into them and so forth. So yes, I mean, the truth is, I know that there are various options available. You have some lots of flexibility if you set up the core pref share and corporate share structure, but where you take it with is case by case.
Yeah. Okay, that's
but the important thing is, I think, if we just stay at the basic level, is that we understand that we've got common shares and pref shares, and that brings with it the sort of core elements of control and growth. And then what we need to do is talk about corporate governance, because once we understand the entity, once we understand the core structure of it, growth and ownership, then the next step is, what do we do with day-to-day control?
And I guess you're alluding there, Ian, to the concept of both directors and then officers of a corporation.
Exactly, and the roles that come with that. So I think that's an important step, and we want to talk through that in our next podcast, because it's the governance now that of the day-to-day operations that needs to be talked through, needs to be communicated and understood in the context of the family arrangements, and especially in closely held families. So let's deal with that in our next podcast.
Great.
And we remember, please go to our blog at estate.law@hullandhull.com.
Or provide us with any feedback or comments you might have at hullandhull@gmail.com. Thanks very much, Ian.